like you to talk about it, because I think that's one of the most fascinating, interesting, and I read the scrapbook,
Yeah.
cover to cover, and there's Arthur Bailey in the middle of it.
Back when the Southern Tier Expressway was being planned in Albany and eventually by the U.S. DOT, the plan was for it to go across Chautauqua Lake at that very narrow point up at Bemis where the Stowe Ferry always theretofore crossed. And it was going fine up until, and don't forget, we're going back into the 60s when environmental law was just coming into the explosion that eventually took on. At that time, I was an officer of the American Trial Lawyers Association and a lawyer in New York, Norman Landau, excellent intellectual as well as courtroom guy, founded in ATLA a new section called environmental law. And we were involved as ATLA in the first Tennessee Valley injunction against the new dam. We were afraid that the last TVA dam in the Tennessee Valley was going to get stopped, and it didn't. I only had 2 small appearances in that, but others in ATLA took it all the way. Fast forward to the Chautauqua Lake Bridge. A professor down at JCC, whose name was Dr. Royal Stubing, and certain people who were kind of followers of his, got an injunction in federal court in Buffalo against the crossing of Chautauqua Lake. And they were trying to force it to go either north of the lake or south of the lake. And
just for the camera, there was considerable construction up to that point.
Absolutely. They were already building it to a point where it was leading up to the lake, but they still got the injunction. And I don't know who or how or even if somebody mentioned that I had been involved in that field, but I'll never forget a great businessman who was a client of mine as long as he was alive, by the name of Norval Reed out in Sherman. And he ran what was called Reed's commission sales out there. Back in those days, everybody in Sherman and Findlay Lake believed that being on the expressway was going to put them on the maps. But when that injunction came down, Norval Reed actually came into my office and said, "Arthur, you've done a lot of good things for me, but I got something now that you got to do. And here it is." And he put in the, all he had was a newspaper article about the injunction. I could not say no to Norval, even though I might want to, and I did want to, because some pretty great firms were behind the original securing of that injunction, from federal judge John T. Curtin. So I went over there, scared to death, and he had 39 or 40 men in his living room. Norval calls a meeting. He said, "Boys, you probably know why I called you here. We got to help Arthur win this case. And I'm going to call him in a minute, and he'll tell us how. But in the meantime, I'm putting the arm on each one of you. We got to have some money to get this done. And the longer we wait, the more advantage the environmentalists," he called them the tree huggers, have. And long story short, he pulled together $5,000, which in those days was a ton of money for an initial retainer. And he brought it over and put it in my lap. He said, "Now, you got to get that injunction stopped. It isn't right." And then he explained from his point of view why it wasn't right. And then several of the other men there did, why they thought it was crazy. I told them that there were federal laws which would override the injunction, but it all depended upon an actual proof in court before Judge Curtin as to whether or not any of the arguments raised against the bridge were really valid, and if so, how valid. And sure enough, that's the way it unfolded. And I was afraid that Judge Curtin would have deaf ears, because theoretically he had already considered these questions before he granted the restraining order. And I was naive enough to believe in those days that once a judge takes that position, it's very difficult and unlikely for him to say he was wrong. It was actually a hearing. And they put on their arguments, the strongest of which was there would be so many footings and concrete piers in the narrowest part of that lake that it would over time have the same effect as a snow fence has with snow. The sediment would slow down when it got to the concrete piers, and when it slowed down, it would eventually settle, and the next thing you know, just like a snow fence, you have a whole collection. And when that occurs, you're going to cut Chautauqua Lake into two lakes. And that's going to affect muskies. That's going to affect other kinds of fish. And they had a whole laundry list of other arguments, most of which were contrived and not supportable. And we had two experts which I thought were compelling, and they were at least good enough to carry the day, and eventually we got that restraining order rescinded and the right to proceed, and I must say Norman Landau did more of it than I did, except we divided the argument equally before Judge Curtin, because me being local and he being from New York might have an advantage. It took almost 2 years, but we finally got the green light to build the bridge where it is. And every time I go across it, I try to figure out from people that are boating all the time whether there's any collections at the bottom of those piers, and give credit to the state engineers. There aren't that many piers. And in any event, boating, fishing, and everything else, that's still the deepest part of the lake is only a 7-iron beyond the bridge. And it hasn't affected it, and God knows that it's been a great thing for the county. That was the first environmental degradation case that was ever around here.
Jim Hastings, Congressman at the time, because this was a relatively new statute that they were hanging their hat on, was trying to get a congressional exemption from this bridge. And, there was debate internally whether the Chamber of Commerce and the group you organized really wanted him to pursue that or just go through the judiciary. Would this be the beginning of another exception upon exception upon exception to a statute which was really brand new?
Yes, and I was always had a dilemma about that because one thing is worse than getting a statutory exception passed, and that is to try to do it and lose, because that has a reverse impact. Now, don't forget that the restraining order that Judge Curtin had signed was based on pure law, not, case law. All of environmental law originally, in its inception, was based upon court decisions. And no matter what Hastings and the House of Representatives were trying to do, and frankly, I think they tried to do it because they were afraid I might lose the case in federal court, which I was too. But one wouldn't have much to do with the other. And since that time, every law school now has, and shortly after that, adopted a whole course, a whole specialization in environmental law. And I don't think there's an accredited law school in the country that doesn't have environmental law as a major component of its curriculum. And it all started back then.